earlier this year. A national government in Europe actually appointed an artificial intelligence program as a functioning state minister, which is just...
It's wild. It's a completely wild concept.
Right. And meanwhile, you have these tech executives going on television and publicly claiming that AI will, soon entirely eliminate the need for corporate lawyers.
Yeah, just rendering entire law firms completely obsolete overnight.
Exactly. So the narrative out there is really that the machines are coming for the gavel. But today, we are looking at a document from, well, one of the oldest, most traditional institutions in the world, the Supreme Court. And they are essentially looking at this tidal wave of technological disruption and saying, not in our house.
It really is a remarkable collision of worlds. I mean, we are talking about the intersection of centuries of deliberate, slow-moving legal precedent with a technology that, practically breaks things by design just to see how fast it can go.
Welcome to the Deep Dive. Today we are exploring a truly fascinating stack of sources detailing the newly released draft regulations for the adoption and usage of AI in the judiciary.
Specifically, we're zooming in on the general principles that are laid out in Chapter 2 of this document.
Right, and we need to point out a very crucial detail for you right away. There is a ticking clock on this. These draft regulations, they're open for public comment only until June 20th.
Which is an incredibly tight window for a policy that will essentially dictate the entire future of how justice is administered.
Yeah, which is exactly why we're here. Our goal today is to decode these really dense legal provisions so you can quickly assimilate the underlying mechanics of what the court is trying to do and, formulate your own view before that June 20th deadline.
Absolutely. Because whether you are a legal professional prepping for a strategy meeting or a software developer building legal tech, or just a citizen who cares about how society handles disputes, I mean, this affects you.
Okay, let's unpack this. We are looking at how the highest courts plan to put guardrails on artificial intelligence. And the document really starts by making it very, very clear who is in charge.
Yeah, Section 4 is the anchor of the entire framework. It establishes the principle of human primacy and judicial independence. And the rule there is categorical.
Meaning no gray area.
Exactly. No gray area. The use of AI in the judicial process will at all times remain strictly subservient to human judgment. The legal definition they actually use for AI here is strictly assistive.
So the AI is essentially the ultimate hyper-caffeinated law clerk.
That's a good way to put it. Yeah.
Like, it can read 10,000 case files in a second, draft summaries, pull up obscure precedents, but it never ever gets to wear the robe. And it absolutely never gets to bang the gavel.
Right. That analogy captures the functional reality they're aiming for perfectly. The AI does the high-volume heavy lifting, but the human signs the order.
Makes sense.
And our source material highlights that this specific provision is essentially a mortal blow to those wilder ideas floating around. The author explicitly notes that this shuts down those articles suggesting companies can just, replace their compliance lawyers with algorithms. The Supreme Court is actually tying this mandate directly back to the Bangalore Principles of Judicial Conduct from 2002.
Let's dig into those Bangalore principles for a second, because that feels really important. Those principles, they govern the ethical conduct and the independent exercise of judicial authority, right? Meaning a judge cannot be influenced by outside pressures.
Exactly.
So by invoking that 2002 document, the court seems to be classifying AI not just as a software tool, but almost as a potential outside influence that could compromise a judge's independent authority if they rely on it too heavily.
You've isolated the core fear right there. If a judge simply rubber stamps whatever the machine generates just because the machine is statistically faster, the judge has implicitly transferred their judicial authority to an algorithm.
Wow.
So Section 4 ensures that the ultimate authority to determine matters of law, to weigh the facts, and administer justice vests exclusively in the human judicial officer. They are legally walling off the actual act of judging.
But I mean, if we follow that logic, it sounds like they're trying to build a high-performance sports car, but they're installing a separate manual emergency brake on every single tire.
That's very accurate.
They want the speed of the technology, but they're terrified of a crash. Because if the human judge is mathematically on the hook for every single output, what happens when the machine inevitably messes up? Because we all know these generative models are far from flawless.
What's fascinating here is how Section 8 handles that exact scenario. They call it accountability, and they completely eliminate the ability to pass the buck.
No pointing fingers at the computer.
None at all. If a judge uses AI to draft a ruling, and that ruling contains a material error, Accountability rests entirely upon the human officer. The text specifically forbids a judge from invoking the opaqueness of a black box system to dodge responsibility.
Okay, so black box system, meaning the algorithmic processes are so layered and complex that even the programmers don't fully know how the AI arrived at a specific conclusion.
Exactly.
So the court is saying, we don't care if the math is incomprehensible to humans. You utilized it. You own the mistake.
Furthermore, they explicitly ban the use of an AI hallucination as an excuse for a palpably incorrect or illegal decision. Any AI-generated output used in court is strictly defined as advisory in nature.
Let's unpack the hallucination concept real quick, because I think it's vital to understanding why the court is so strict here.
Yeah, it's a huge issue.
Because when an AI hallucination occurs, the system isn't just making a calculation error, right? Large language models work by predicting the next most likely word in a sequence based on their training data. They don't actually query a database of objective truth.
Right. They're just probability engines.
Exactly. So if a judge asks the AI for a precedent supporting a highly specific, very unusual argument, the AI might just invent a fake case name, complete with fake citations, because those words statistically look like a valid legal response.
And the scary part is, the machine speaks with supreme confidence, even when it is completely fabricating reality.
Yeah, it doesn't know it's lying.
Right. And because of that architectural flaw in the technology, the regulations demand that reasonable care must be taken by the human to manually verify the accuracy of the output before it is ever utilized in a ruling.
Okay, wait, let me challenge this from a practical standpoint on behalf of the listener.
Sure, go for it.
I am looking at a judicial system with a backlog of millions of cases. If I'm a judge and I have to manually verify every single citation, every historical fact, and every summary the AI generates by going back into the physical library or the digital database myself, I'm doing the work twice. Doesn't that completely defeat the purpose of using the AI in the first place? You've basically just neutered the speed that made the technology valuable.
And that right there is the central tension of the entire draft document. The drafters actually recognized that bottleneck, so they carved out a highly specific exception for administrative, non-adjudicatory functions to keep the system from just, grinding to a halt.
Okay, define non-adjudicatory functions for us. We're talking about the background machinery of the court, not the verdicts.
Correct. Things like scheduling hearings, sorting incoming digital filings by jurisdiction, managing docket flows, or translating basic procedural notices.
Just the day-to-day admin stuff.
Exactly. These are tasks that do not involve deciding the actual outcome of a legal dispute. So to streamline this, the regulations introduce the concept of an AI secretariat.
So this secretariat is basically a regulatory body functioning inside the judicial system.
Yes. And their job is to evaluate specific AI tools. If the Secretariat certifies that an AI tool has established reliability for a specific administrative task, it can be deemed to satisfy the verification requirements on what they call a class basis.
Class basis. Let me see if I can translate that. Think of it like a safety crash test for a new car model. Right. You don't crash every single sedan as it rolls off the assembly line.
Right.
The Secretariat puts the AI through a rigorous sandbox test, say, feeding it 10,000 dummy scheduling conflicts. If it resolves them with near-perfect accuracy, that class of software gets a permanent green light.
Exactly. And then the judges and the clerical staff can use that specific scheduling tool without having to manually verify every single calendar invite. It allows the court to gain massive efficiencies on the administrative side while maintaining that absolute human firewall on the adjudicatory side.
So routine paperwork gets the express lane, but the actual interpretation of law gets scrutinized at every syllable.
Exactly.
Which makes sense, because if the judge is taking the fall for any legal errors, their only defense is ensuring the AI is reading from a flawless textbook to begin with. And that brings us directly to Section 5, the actual raw material feeding the machine, the data.
And here is where the constitutional states become incredibly apparent. The regulations place a massive emphasis on the integrity of the data. We are talking about strict principles of fairness, transparency, and privacy.
Heavy hitters.
Yeah. Section 5 mandates that no AI system shall be deployed that perpetuates, amplifies, or introduces bias based on race, religion, caste, sex, gender, disability, language, or economic status.
Here's where it gets really interesting. In the tech world, there is a very old, very simple adage: garbage in, garbage out. If you train an algorithm on bad code, you get a buggy app. But when you apply that concept to a judicial framework, We are scaling up the consequences astronomically.
Oh, absolutely.
If a court AI is trained on biased garbage, we aren't just getting bad code or a glitch, we are getting constitutional rights violations at scale.
And our source material highlights the acute danger here. The drafters mandate that special care must be taken to protect the rights of vulnerable groups, including marginalized communities and persons from socially disadvantaged backgrounds. They recognize that an AI is only as objective as the historical data it consumes.
Which obviously requires heavy regulation on where that data comes from. I notice the text insists the data must be lawfully obtained. They explicitly tie the processing of personal data to the Digital Personal Data Protection Act of 2023, the DPDPA.
They do, yes, and they lean heavily on two specific pillars of the DPDPA: purpose limitation and data minimization, meaning the court cannot simply scrape the internet or even its own vast governmental archives to train a neural network without restriction.
Let's break down purpose limitation for a second. If I understand the DPDPA correctly, that means if a citizen provides their personal data to the government, specifically to register a vehicle, the judicial system cannot secretly harvest that vehicle registration data to train an AI model on predictive criminality.
Exactly.
The data's purpose was the vehicle registration, full stop.
The law builds a definitive wall around the original intent of the data collection, and data minimization takes it a step further. It dictates that even if you have a valid purpose to use someone's data, you are only allowed to extract the absolute minimum amount of information necessary to complete that specific task.
So no fishing expeditions.
Right. If the AI only needs a zip code to verify jurisdiction, it cannot legally ingest the individual's full home address and financial history just because it happens to be in the file.
So they are actively starving the AI of extraneous personal details by design to prevent it from forming unauthorized connections.
Yes. And if we connect this to the bigger picture, the court is looking at the socioeconomic footprint of the technology itself. The document dedicates an entire section to inclusivity and accessibility. The court explicitly mandates that AI deployment must not create or widen the digital divide.
The digital divide. We usually hear that term regarding who has broadband internet access and who doesn't.
Right, the hardware side of things.
Yeah. But in the context of an AI interacting with the public, this is really about representation, isn't it?
Yeah.
If an AI chatbot is designed to help citizens file small claims paperwork, but it's only trained on formal, elite legal English, it becomes completely useless to someone speaking a regional dialect or interacting with a lower literacy level.
Exactly. The regulations demand that the benefits of AI-assisted judicial services must be extended fairly to all stakeholders. They specifically name rural communities, economically disadvantaged individuals, and linguistically diverse populations. The AI cannot function as a luxury concierge just for corporate lawyers in major tech hubs while leaving rural litigants behind. It has to be engineered for universal accessibility.
Let me pause and synthesize this architecture we've been building because it is incredibly dense. We have strict human subservience, a total ban on the black box defense, mandatory manual verification for any legal decision, intense data audits, strict adherence to purpose limitation, and a mandate to solve the digital divide.
It's a lot.
It feels less like an adoption strategy and more like a containment strategy. Honestly, do they actually want to use this technology at all?
You've isolated the great paradox of this entire draft right there, because despite laying down one of the most restrictive regulatory gauntlets imaginable, the text simultaneously preaches the exact opposite message. If you look at Section 17, it is literally titled, Innovation Over Restraint.
Wait, so they slap a flashy innovation over restraint title on the chapter, but then bury the actual functionality in so much red tape that the AI can't do the heavy lifting? That sounds like pure lip service.
I mean, the text itself says that every court shall actively seek opportunities to deploy AI systems to improve access to justice and reduce delays. It even states that unless proved otherwise, the presumption shall be in favor of responsible adoption of AI. They are actively asking innovators to come in and solve the backlog.
But there is a hard line buried in that section, isn't there? A very specific type of software they absolutely will not tolerate.
There is. In the very same section encouraging innovation, they establish an impenetrable boundary. AI can never be deployed for dispute outcome prediction.
Dispute outcome prediction. Okay, let's make sure we understand the mechanics of that. This means you cannot feed the details of a pending lawsuit, the evidence, the jurisdictional history, the judge's past rulings into an algorithm and ask, based on historical probability, who is going to win this case and what is the optimal settlement number?
Correct. That exact scenario is strictly prohibited. The court refuses to allow justice to be gamified into a probabilistic calculation. And this actually brings us to a highly critical perspective from the author of our source material. The author analyzes this contradiction, the title, Innovation over Restraint, versus the reality of banning predictive models and requiring manual verification, and concludes that restraint obviously overrides innovation.
Why does the author think the drafters took such a defensive posture?
Well, authors suggest the regulations were drafted in a state of institutional panic.
Panic.
Yeah, panic. There is a palpable fear that if they give the technology an inch, the sheer volume and speed of AI will overwhelm the system, eventually leading to the wholesale elimination of human adjudicators. The fear of the robot judge is really the invisible hand guiding this entire policy.
Okay, put yourself in the shoes of a software developer listening to this. You've spent millions building a brilliant AI tool to analyze legal arguments and predict outcomes, aiming to help clear the massive backlog of cases. What are you supposed to do with such rigid rules? If predicting outcomes is completely banned and you have to clear an AI secretariat just to sort documents, where is the actual space for innovation?
It's a great question, and our source author actually provides a strategic pivot for those innovators. Recognizing the massive delays clogging the formal court system, the author advises innovators to shift their focus outside the traditional courtroom. They suggest pushing advanced AI usage into mediation processes and what is known as with recourse arbitration.
Let's define with recourse arbitration, because that sounds like the magic loophole. Arbitration is a private dispute resolution process outside of court. What makes it with recourse?
With recourse simply means that if you go through the private arbitration process and completely disagree with the final ruling, you still retain the legal right to appeal that decision back into the formal, traditional court system.
Ah, I see the strategy. Because that human safety net still exists at the end of the line in the formal court, innovators can deploy heavier, more predictive AI tools at the lower arbitration level without triggering the Supreme Court's constitutional panic.
Exactly.
You can bring your predictive models to a mediation table, run the dispute outcome predictions to show both parties what a statistical trial looks like, and essentially force a settlement all without running afoul of the Supreme Court's ban because you aren't doing it inside their formal adjudicatory framework.
Precisely. It is finding the tactical space where technology can still solve the societal problem of legal delays without colliding with the rigid traditions of the formal court.
So what does this all mean? We started this deep dive looking at a visual clash, a heavy, ancient wooden courtroom being invaded by a humming, state-of-the-art server rack. And what we've discovered is a draft document desperately trying to referee that exact collision. For you listening, whether you are drafting a public comment to submit before the June 20th deadline, or you are simply trying to understand how our oldest institutions are handling the AI revolution, these regulations really represent a defining historical moment.
We are watching a foundational pillar of society attempt to domesticate our most unpredictable technology. They recognize the desperate need for efficiency to clear the backlogs, but they are drawing a hard boundary to protect the fundamental, non-negotiable human right to a fair trial.
They desperately want the hyper-caffeinated law clerk to help them work faster, but they are terrified the machine is going to try and steal the judge's robe. It is a tightrope walk between progress and preservation.
Absolutely. And as we conclude, I want to leave you with a final thought to mull over, building directly on that tension. We spent a lot of time discussing the court's strict ban on dispute outcome prediction and their deep fear of biased data sets. We know that AI learns by mathematically weighing historical data, right?
Right. It is entirely reliant on the past to predict the future.
Therefore, if an AI is trained on historical court data, its algorithms will inherently bake in all the human biases, the systemic flaws, and the prejudices of past rulings over decades or even centuries.
Wow, yeah, it essentially mathematically codifies our historical failures.
Exactly. So here's the question. The regulations strictly prohibit using AI to predict the outcome of a dispute. But if the AI is mathematically reflecting our own historical data, might a banned outcome prediction tool actually be the exact mirror we need?
Oh.
If we allowed an AI to predict outcomes and we watched it routinely output biased results against marginalized groups, wouldn't that finally give us the auditable, undeniable proof we need to see and correct the historical prejudices embedded in our own justice system? By banning the mirror, are we just choosing to look away from our own flaws?
That completely inverts the narrative. Are we banning the predictive AI because we are afraid of what it will do to us, or because we are terrified of what it will show us about ourselves in that courtroom? That is a brilliant question to leave off on. Thank you so much for joining us on this deep dive. Remember, the deadline for public comment on these draft regulations is June 20th. Read the sources, formulate your own views, and as always, keep questioning the information around you. We'll catch you next time.